Yes, okay. First of all, I'd like to further explain some of the procedure we'll follow today. For the sake of getting across to you full, complete, and a better understanding of our position, we brought with us, as you can see, a large delegation, which can cover a wide cross-section of questions, anywhere from legal to political. To a great extent this afternoon, I'll be answering the political aspects of it. The detailed legal parts of it, I will refer to people within our delegation. To get to your first question on self-determination, again, I must go back in history, back in time, prior to 1867, prior to the existence of your government as we presently know it. Indian people were very traditional people. We've always had a form of self-determination, a form of our own government. For a great number of years, since 1867, a lot of this has been suppressed, and our governments have had to, I guess, go underground. We've had to adopt systems that were imposed upon us, but our own forms of Indian government, self-determination, have always been there. They're now resurfacing. They're coming about. They're happening, and it's only been in the last few years, the last 10 years, the last 20 years, that we've developed the kind of leadership that's required to fulfill any objectives within self-determination for our people. And we're beginning to exercise these ourselves today, irregardless of any impending legislation. But self-determination has always been very important to us. It's extremely important in the sense that if we're to progress, if we're to move ahead in any way in the future, we must control our own future. The answers do not lie in the system that's presently upon us, whereby decisions that affect our future are done in some office in Ottawa without any involvement of Indian people. And I must stress, I've had absolutely no, or next to no connection with this Office of Indian Affairs here in Ottawa in the past 3 months. I've had no relationship with them whatsoever. And a matter of fact, I'm getting a little away from this concept of self-determination, but I just wanted to demonstrate that this is something that we still believe in, and that we're going to move ahead in spite of any obstacles that are either put in front of us or imposed upon us. But it's very important. Indian government, you can conclude as being essentially the same as self-determination. But it's something that we've always had. We've always had this distinct form of Indian government anyway.
Mr. President Riley, when I read the Indian Act, and I know we could spend some time on that act itself, as many of us have done before, but when I look at the definition section, and I take a look at the history of the last 10 years, and going back to 1969, I know in the 1969 white paper there were a number of terms that were unacceptable both to your people and to those of us who at that time might not have been in public life, but who had an interest. And 1969, if I recall, and having read those debates subsequently, I think there was a general understanding, as there is today, that Indian government, the very basis of Indian life is the chief and council as a form of Indian government. That is where the wellspring of power comes from. That is the source of government among the Indian people. And that the 1969 white paper, that one of the difficulties with that paper was the so-called concept of termination, and the concept that with termination, the Indian people, or responsibility for the Indian people, would be transferred from the federal government, that is 9124 would not be operative, to that of the provinces. You commended the provinces for having resisted that. I am not so sure, in the light of having read 1969, whether it was the provinces' desire to protect Indian rights that led to that, or was the motivation of that action, or whether they didn't want to take the responsibility. I think history might record that slightly differently from the impression I had in your brief. But that aside, I look at that period, that while those mistakes were made, that the Indian people today are coming to the concept not of the 1969 white paper, but that Indian government, self-determination, in fact must have its wellspring at the local level, with the chief and council. And that is the position, and I hesitate to use the word of municipal government, but for those of us who are familiar with that term, that there is, if not an equal, at least there is a parallel. Does that describe your position today on self-government?
No, not exactly. It's true that the chiefs and councils are, these are recognized as the, I guess, the local forms of government. But to some extent, that's only partially true. There's also the traditional forms of government. And the source of jurisdiction, there's a presumption that under this form of administration, that the source of power arises out of Parliament. And this is not a view held by the Indian nations of Canada. As sovereign people, as people that have never given up their sovereignty, we see something substantially different.
Do you see a level of government?
Well, originally I mentioned that we would like to join Confederation. We would like to be included in any new constitutional reforms, yes.
Thank you very much, Mr. Hepp. Mr. Minley, followed by the Honourable Senator Jack Austin. Mr. Minley.
Thank you very much, Mr. Chairman. I'd like to commend President Riley and the National Indian Brotherhood for their very positive approach to this subject. I think, first of all, that the committee should note the very substantial agreement between the position that you presented and the amendments that you presented, and the amendments that were presented by the Native Council of Canada and the Inuit organization, because I think this represents a great deal of progress in these three organizations sitting down and working out some kind of a common approach. And this progress was made in the face of very great time constraints upon you and in relationship to this committee. I would suggest that probably this progress was possible in such a short time because you and other Native peoples all across the country recognized the basic threat in the present resolution to your rights and to your continuance as a people. 2 weeks ago, I had the opportunity to sit in on the First Nations conference where over 1,000 Indian people from all over the country worked to come to grips with the problems involved in the Constitution. And I'm very glad to see that the National Indian Brotherhood did have the opportunity to appear before this committee, and like others, I regret that it's not possible for more of the constituent provincial groups to appear. my impression that the Canadian people generally recognize that great injustice has been done to the Indian people since the coming of European explorers and settlers several centuries ago. And Canadians are generally in favor of government action to redress this injustice, but they're also very uncertain as to what is required. And they have some problems with the concept of special status. And perhaps we can illustrate this, and I'd like your comment on it, with regard to your statement, we want to join Confederation. And the average person in the street is likely to say, well, why can't they just become citizens like all the rest of us? And I think that not only are there pressures in government towards assimilation, but that a lot of ordinary Canadians don't see anything particularly wrong with that. And I'm wondering if you could speak to that issue. What do you mean when you say we want to join Confederation?
Mr. Chairman, thank you. Okay, what I meant by us wanting to join Confederation was the fact that we, and I think to some extent, you, and to a great extent, Great Britain have recognized us as individual nations. We have always held that this is true. And as a matter of fact, the whole treaty-making process that we underwent with you was along those lines, that we are independent nations of peoples. We welcome you here to this country. We're going to share with you this country, the resources of it, and that's always been our basic position. We do not want to be the same as you. We have a right to self-determination, a right, I think, that's recognized by the United Nations and by Canada, that people do have a right. They also have a right to tribalism. This is rights that we've always maintained for thousands of years prior to your coming, and we want to hold on to these collective rights, which I think Canadian people, this government, finds difficulty with.
Perhaps you'd say that the process that began with the making of treaties in some areas should now be continued, so that there can be some kind of a social contract with the different Indian nations across the country to bring them into a general agreement with the rest of the country. Is this what you're saying?
Well, basically what the questioning is leading into some negotiation, and we would have hoped that this process would have taken place at a much higher government level. But I think we could have gotten a much better understanding across to the government if they would have sat down with us to attempt to acquire this understanding. I'm not suggesting that that is the only means. I would suggest that if the government and if the Indian nations of Canada are inclined to move in that direction, that would be subject to negotiation between those nations and the government.
You've talked a fair amount in your brief about the Royal Proclamation of 1763, and could you briefly summarize your view of that Royal Proclamation, and what does it mean to you and to your people in 1980?
Okay, I'll deal partly politically with that question, but I'm going to refer that question to our legal counsel, the other part of it, so that it can be better understood by the committee in the kind of detail I think that it requires. The Royal Proclamation, as far as Indian people are concerned, did not give rights to Indian people. It recognized rights, and these rights, which we call Aboriginal rights, are rights that we've always had. it was a document that I guess set out some procedure in which the British government would deal with the Indian nations in Canada, and that procedure I'll ask Bill to explain further.
Thank you, John. Mr. Chairman. Mr. Manley, as you realize, the Royal Proclamation of 1763, as President Rowley pointed out, did not grant rights. It confirmed and recognized rights that were already there, something that apparently the government didn't consider when they introduced Bill C-60, because in that bill it specifically said the rights that were granted by the Royal Proclamation. So we want to get that very straight now, that those rights were not granted. They were recognized in the Royal Proclamation of 1763. That document has never been repealed. It still has the force of statute in Canada. As a consequence, it outlines exactly what the position should be between the Indian nations of Canada and the Imperial Crown. When the Imperial Crown passed the, if you will, the self-determination of Canada over to Canada, Canada was bound by that kind of a recognition. Unfortunately, although that may be a de jure recognition, de facto it has not been recognized at all. And through the years, the courts have consistently denied that we're Indian nations. They consistently denied that treaties have the stature of international treaties. Rather, they've looked at them as mercantile contracts or of some kind of a contractual obligation. And so to the Indian people of Canada, the Royal Proclamation is very important and should be part of the constitutional papers of Canada because of the recognition it makes of Indian nations as nations, a recognition that has never been given up by the Indian nations of Canada.
There is some confusion over the whole definition of Aboriginal rights, and I'm wondering if you can give examples as to what Aboriginal rights are, and perhaps say something about the record of the federal government in protecting your rights.
Aboriginal rights is causing a lot of concern to a lot of people, and to a great extent it's going to be a subject of further negotiation. But much like the Trade and Commerce section of the original concept V&A Act of 1867, it wasn't defined at that time. Again, we must proceed on the basis that we must further sit down and negotiate the definition of this. But if you would look at Section 23 on the attachment to our brief, it will give you a good basis on which to start on the areas that we must discuss on Aboriginal rights.
I think that this is one of the very positive features about your proposals, is that it does allow for negotiation. One of the promises that has been made is that you and your concerns can be the number one item on the agenda after the Constitution has been patriated to Canada. Why do you object so strongly to this?
Because of the assimilationist policies of this government and previous governments on Indian people, because of the oppression, because of the oppressive nature of the Indian Act, the taking away of the human rights of people, this practice, because of the fact that it's been continued, it's been the policies of governments up until now, we have no reason to trust the goodwill of the present government to negotiate it with us after. That's why we want guarantees now.
Thank you very much, Mr. Manley. I'm sorry, Mr. Manley, if you might look at the chair sometime, I could give you an indication of how much more time is at your disposal. I still have the name of Mr. Nystrom on my list. I would like to invite Senator Austin to continue our discussion, followed by the Honorable James McGraw. Senator Austin.
Thank you, Mr. Chairman. Along with other members of the committee, Mr. Riley, I would like to welcome you on behalf of myself and the government members. We have been looking forward to your brief, and indeed we're not disappointed It's an excellent contribution to the discussion that we have been having and will have. I feel that whatever the difficulties in your coming before the committee, they are certainly totally to the advantage of this committee if it was required by yourselves to take a little extra time to prepare this particular presentation. I had an opportunity to discuss some of the key issues with Mr. Powderface, your vice president. I welcomed that opportunity. It was a very much to the point kind of discussion, and I will come back to the same kinds of points in my questions. I think that the nub of it for me, and I will not take time for flourishes and rhetoric, but to come to what I think is the key problem is the one that you were responding to a moment ago when Mr. Manley put a question to you about the issue of when your rights would be entrenched. You are very much aware that at best Section 24 of the present joint resolution seeks to be a without prejudice kind of clause. It seeks, whether it does it well or does not do it well, its intention is to say this joint resolution is without prejudice to Aboriginal claims or without prejudice to the points of substance that are ongoing between levels of government in Canada and various Native communities. We could discuss whether it works or not, but your brief is fairly clear in saying it doesn't. And that isn't the general point that I want to move into. My concern is very much with the problems that you have in enhancing the position of your community, the Native, the Indian community in Canada. And I would like to put on record the position of the Liberal Party at its policy convention in July 1980, a position which was briefly referred to in your document. Madame Payette and I were the co-policy chairman at that particular convention. And it was unanimously passed that the Liberal Party of Canada work towards the entrenching of Original and Native peoples' rights by enacting legislation with the consent of the Original and Native peoples that clearly provides for Canada's obligations by virtue of Aboriginal and treaty rights, and B, implementing a modern settlement policy that provides for orderly development by enhancing and not extinguishing Aboriginal, treaty, and Native peoples' rights, and C, include the Original and Native peoples' representatives at all levels of constitutional reform discussions, and D, amending Liberal Party policy to recognize the true cultural, political, and legal status and rights of the Original and Native peoples of Canada, and E, a new Canada Indian Dene Native process, direct immediate economic action for mutual advancement towards an independent quality of life for all citizens of our nation. And it is a policy that the party is endeavoring to shape with the government. I remain a member of the Liberal Party's National Policy Committee, and I can assure you that the question of Indian and Native rights is very much at the fore of our concerns. What really bothers me is the difficulty of the negotiations that we have had as a federal government and you have had as an Indian people with the provinces. And I know the experience in my own province of British Columbia of the Nisga'a, who have as good a claim established in the common law as has been established to date. And they were here before us earlier today. So the committee is familiar with the position of the Nisga'a. But we have been unable in British Columbia, and I think anywhere else in Canada, to bring the provinces to a recognition that it is they that must implement the territorial claims of the Indian people. It is they that must implement a long number of things for the very reason that under the division of powers in Canada, they have the constitutional responsibility for the delivery of many, many of the remedies. Now, I find it rather difficult to listen to Mr. Epp, who said when he opened that we should not proceed when there is dispute among the provinces, and he made reference to the Indian culture. And I am not going to make any reference to the Indian culture, but I will refer to the political situation. And what the government is trying to do in this resolution is create the concept of entrenchment, to put certain rights entrenched in the Constitution. The Prime Minister has said that, and this is something I will come to with you, that Native rights will be at the top of the list for First Ministers following the establishment of the entrenchment system. And we hear, particularly from the Progressive Conservative Party, that they believe only in a formula of unanimous agreement, that they believe indeed in the supremacy of Parliament, including the provincial legislatures, so that in my terms, if not in theirs, they believe in continuing the deadlock under which you have been negotiating for a very long time. Well, Mr. McGraw, you'll have a chance to correct it, and I hope you will correct it, because I would indeed like to believe differently of the position of your party. But I would like to ask you whether you think that there is any chance of serious negotiations with the provinces on their sharing the responsibility for the settlement of Aboriginal rights in Canada. Do you have any faith that any of the provinces will come forward with remedies for your rights in the near future?
I can answer that very shortly. Absolutely not. And
all right. Now, if that is the case, and if the federal parliament wishes to encroach on provincial legislatures and the jurisdiction of provincial legislatures to establish your rights and the rights of others who are claiming rights in Canada, would you support the federal parliament in establishing an entrenchment system that does indeed require provincial legislatures to deal with a superior law than their own supremacy as legislatures?
I'd like to say that, first of all, one of the problems we see in the proposal to amend the Constitution is in the post-patriation period, is that at that time we'll be pitted against the provinces, and we've always had diverse interests.
In this case, you would be pitted against 6 provinces in accordance with the amending formula, rather than each province being sovereign by itself. Does that not improve your situation?
Well, I think even if you got it down to 3, it would still be hopeless.
Okay. Please continue your answer then.
I don't, I would have liked any discussions of this nature to have been part of a negotiating process with the federal government, a process that we should have begun a long time ago, much long before we've ever appeared here. And I don't think we could agree with that type of a proposal at this time. We'd have to sit down and study it, look at it, examine it carefully. And, you know, it's very difficult to have something thrown in front of you and then say, well, do you agree with it or don't you?
Well, I'd like to say to you, Mr. Riley, that I too wish that we were in a position where today we could entrench rights that would be understood by a court. And we could do it before the patriation process was completed. The real dilemma, and this is the one that Mr. Manley referred to and Mr. Powderface and I discussed. The real dilemma is that the provinces have resisted our being where we would like to be. And either one or the other choice is going to take place. Either we're going to create an entrenchment system today and then have a more flexible formula for amendment, or we are going to defer the entire process, as the Conservative Party would like us to do, until there is some unanimous agreement with the provinces on an amending formula, and you and I have about the same faith that we will end up breaking the deadlock by agreement between the federal government and all the provinces. So it comes down to this. Can we do something at this stage that is a just treatment of your position without unduly changing the course of the, prejudicing, I guess is the word I want to use, the course of the negotiations which should continue at arm's length? Is there some way we can recognize your existing rights better than we do in Section 24? Now, I know that you have suggestions in your document.
Yes, follow our suggestions.
Well, let's say that we can't follow them all. Would you accept, for example, a movement back to the C60 language that refers to the Royal Proclamation of 1763, which Mr. Babcock spoke about a few minutes ago? Would you go back to that language as an improvement over what we have now?
Okay, I'm going to refer that question to one of our legal advisors.
I think, thank you. I think the position on the Bill C-60 language was made clear at the time and has been reiterated now, that the idea of a positive reference to the Royal Proclamation of 1763 is seen as very important and is proposed. What was a mistake in 1978 with Bill C-60 was to refer to the proclamation as a source of rights rather than a recognition of rights, which would have locked us again into some quite unfertile historical arguments. I would like as well to say that there are things that the federal government is able to do and have not done. The position that was taken in 1973 by the federal government on Aboriginal title claims focused exclusively on the proposition that Aboriginal title claims had been lost, and therefore did not recognize in the language of that statement the fact of continuing use and occupancy of lands by various groupings within the country. This precluded, in a self-serving way, the federal government from asserting jurisdiction over Aboriginal rights that continued, in fact, in the country. Under Privy Council rulings, the federal government has jurisdiction over lands reserved for the Indians, and that is not limited to the concept of Indian reserves, as we commonly understand that term within the country, which means that the federal government would have constitutional jurisdiction if it chose in a situation like the Nishka situation, where there has been a political impasse in dealing with the province, to say to British Columbia that it has jurisdiction over the lands and natural resources of the traditional Nishka lands and will therefore act on that unless the province is willing to negotiate and agree. In other words, the federal government could come forward under its present jurisdiction under 9124 and say, we will confirm in the Nishka their timber rights and their water rights and their fishing rights in the area. This would be seen as, by the province without any question, as some kind of a constitutional challenge by the federal government. The fact is that the federal government, to my knowledge, have never even been willing to make this threat. As well, under what we regard as very conservative opinions being given by the Department of Justice, it is the present position of the federal government to deny the existence of Aboriginal title claims in most of British Columbia and in all of Nova Scotia. This is a position which doesn't have very much public visibility. Perhaps there's reason for that.
Thank you very much.
Senator Austin.
Am I done already?
You are overdone, Mr. Austin. I would like. Yes, I would like.
A long time ago, Jack.
I would like to remind the honorable members of this committee that for the next round it's a 5-minute rules, and I say that in deference for our guest, and you will understand that it will allow to a greater number of members to have a discussion and exchange with you. Honorable James McGraw, followed by Honorable Senator Lucier. Honorable McGraw.
Mr. Chairman, you're not so subtle reminder that this is a 5-minute round will give you some idea of how important I feel about this matter, because I'm going to take up a part of my 5 minutes to address myself to something that Senator Austin just said. You know, we have developed a kind of spirit of civility in this committee, and we don't interrupt each other as a consequence. And that imposes upon each of us a discipline not to misrepresent.